Good morning, students. So, today we are going to look into the topic of parental and quasi-parental authority and the application of these two concepts in India. What are the concepts relating to these two aspects? Now, when we talk about parental authority, it has been taken up by various researchers, and they have assumed these researchers have assumed that parents have a critical influence on children behavioral, emotional, personality, and cognitive development. Parental authority is what refers to parents' rights and responsibilities towards their children from the minute they are born until they turn 18. Under their parental authority, parents make decisions that affect their children's well-being. For example, parent can make these decisions where the children will live, agree to or refuse health care. There are limits to this right for children for of 14 years or older. Pass on their religious belief is another right that parents hold towards their children. Now, when we talk about common law system, we say that the common law system, however, gives the parent only a moderate degree of authority over his child persons, and the parental chastisement must be moderate and must be exercised in a reasonable manner. And if the parent exceed the bound of moderation and inflicts cruel and merciless punishment, he is liable to be punished. Now, this is the observation which was taken up by the court in one of the landmark case of Sankani versus Swami Nath Pattar. Now, when we talk about aspect that is relating to what is covered under the parental authority, it was in the matter of Lovejoy Patel and versus Unknown, which is a very old decade of 1944, where the principle on which the common law court acted was that the parent, as against other person, generally had an absolute right to the custody of the children unless he or she had forfeited it by some gross misconduct. This absolute right of the parent was recognized because such a right was necessary for preserving the natural order and course of the family life, which is the foundation of the society. Now, the court of common law did not interfere with the parents except upon grave occasions or for reasons of urgency. Now, the law recognized the natural right of the parents because it recognized the natural duties also that a parent is bestowed with. It is the natural affection of the parents for the child, which is a security for the performance of duties towards a child, and performance of the duties alone qualifies a parent to claim the absolute right. It is the natural affection which makes them the natural guardian. The right of the parents are sacred rights and their duties are also sacred duties. These are certain principles which are laid down in the given case. Further, it was stated by the court that cruelty and gross immorality render the parent unfit to perform the sacred duties, and therefore, on proof of such misconduct, they cannot be allowed to claim the sacred rights. Parents guilty of gross misconduct become unnatural parents and cease to be a natural guardian. And when they cease to be a natural guardian, they cannot legitimately claim the right of a natural guardian. These are few principles that have been laid down and that are still applicable if there is any case that comes up before the court with respect to the rights of of a parent to maintain their child. Especially when we talk about the position that exists in India, it has been stated that parental act is one that is initiated or enforced by a parent with the sole purpose of enforcing, initiating. Such an act is reform, correcting the child or individual. This is an instinct right vested with the parent, and the act of a parent in this regard cannot be challenged before the law unless and until it is beyond the reasonable ambit. However, the reasonable act that the court is talking about shall not constitute arbitrary punishment or unlawful command to the child. These are certain considerations that are taken up by the court while deciding whether a person has exercised the parental authority or not. Because there are certain duties which are also imposed under Indian law on Indian parents for the betterment and welfare of a child. Like for instance, if we take the provisions that are there under Indian law are section 20 and 125, 20 of Adoption and Maintenance Act 1956, that talks about the maintenance of children and aged parent by a person. Current provision cast a duty on a person, on parents, to maintain their aged parents as well as their children, and the concept of children include both legitimate illegitimate child as well as daughter who is unmarried. So the provision of section 20 of Indo Adoption Act is legally imposing a duty in of a maintenance of children that can we can relate to as to the duty which is there, and that can be covered under the concept of parental authority. Another provision that talks about the authority, parental authority, and the duty that is casted upon parents is section 125 of CRPC. Their power is given to a magistrate of first class to order monthly allowances to any child, which is that includes the concept of legitimate, illegitimate minor child, whether the person is married or not, and also include any legitimate or illegitimate child who has attained majority, but because of physical or mental abnormalities, the person cannot maintain himself or herself. So, a duty is casted upon the parent to maintain such children of theirs, and also for the allowances that are there for a wife, a child, father, or mother. And this monthly allowance is something which is decided by the magistrate of first class. To better explain this provision, we can take an example for a case, which is Padma Sharma versus Ratan Lal Sharma. Now, in this case, it was held that a Hindu earning mother is also obliged to maintain children. It was held that a Hindu divorcee father and a Hindu divorcee earning mother are obliged to contribute for maintenance of the children under the Hindu Adoption and Maintenance Act. Only the father is not exclusively responsible to maintain children, regardless of their mother being capable of earning. So this is one of the instances that says that the parents are equally liable, equally have duty to execute their duty of maintenance towards their child. Question is as to what are the duties and responsibilities, rights and responsibilities that a parent have. So we can conclude with this that it is the custody, right to supervision, physical and psychological protection is one of the right to health and safety, right to education, that they can exercise over their ward. Providing food, caring for them is are certain duties and rights that a parent should have towards their a child. Now, when is this parental authority lost? Right? In rare cases, a parent can lose all or a part of parental authority and the right to make decision concerning the child. And this is something which is decided by the judges. So that the judges can take away the parental authority wherever they are of the opinion that parents have failed to perform their parental authority, keeping in mind the welfare of the child. Next, we need to understand as to what do we understand by the term quasi-parental authority, which means certain people are given authority like parent and they are bestowed with certain rights and duties in place of parents wherever parents are not physically present for the welfare of the child. Now, when we talk about quasi-parental authority, it is what has been classified as when a child is sent by parent of his guardian to a school, the parent or guardian must be held to have given an implied consent to its being and under the discipline and control of the school authority, and to the infliction of such reasonable punishment as may be necessary for the purpose of school discipline or for correcting the child. The current principle relating to the quasi-parental was accepted by the Rangoon High Court in King Emperor versus Mongba Thong case. From this, we can infer that school authorities that mainly deals with talk about principals and teachers have been given quasi-parental authority. There are many cases wherein the same principle has been laid down and where teachers, principals have been allowed to act within the reasonable limits and for the welfare of the child. Now, this is a case R.C. Thappan and other where the writ petition was directed against a disciplinary action that was taken up by the management committee of a medical college on the ground that the student has acted in a wrong manner by taking the action of ragging, that the student was indulged in the action of ragging, who was the senior student of the college, and this ragging was taken up as against the freshers or the junior students. In this case, the court has made a very good observation that said that the inherent right and the quasi-parental authority of a teacher to proceed by way of disciplinary action against a pupil under the charge has been well recognized over the years, and we should think it's ingrained in the habit of thought and philosophy of our country. So in this case, court has also referred to the position that existed under English law, and they stated that according to the English to the law of England, the authority of the schoolmaster is, while it exists, the same as that of the parent. It is stated that the parental authority is delegated to the schoolmaster, and that the schoolmaster represents the parent for purpose of correction. Time and again, courts have decided this aspect that when the child is in the custody or is in the school premises, they are the responsibility of school administration to make sure that the proper upbringing and welfare of the child is taken care of. There is a landmark judgment, that is Sanquini versus Swaminath Patta case, and one of the well-known early case in which quasi-parental authority of principal of college was expounded by the court, and there were various questions that were raised, that what is the extent of rights possessed by schoolmaster, is the punishment actually inflicted by defendant upon the plaintiff is justified or not, and if the punishment is not justified or there is unreasonable exercise of the duty, to what damage is the plaintiff entitled to. So in this case also, court has referred to various foreign judgments and had made an observation, has stated an observation that was made by Chief Justice Cockburn in Regina versus Hopley, and it follows that which was stated that for purpose of correction, the schoolmaster may inflict a moderate and reasonable corporal punishment, and it was further stated that if it be administered for the justification of passion or of rage, or it be immoderate and excessive in its nature or degree, or it may be protracted beyond the child's power of endurance, or with an instrument unfitted for the purpose, and calculated to produce danger to life or limb, in all such cases the punishment is excessive in nature, and the violence is unlawful, and where it is not allowed even if there exists quasi-parental authority. However, in this case, court has said that the defendants have not exceeded their authority, and the punishment was of moderate nature, and whatever the punishment is inflicted is not unreasonable, and is what is required as per the rules and regulations of the school. Other cases, like in the current case, Chief Justice Menon has said that headmaster is of pivotal importance, and in the life of the school, around him wheels the tone and temper of the institution. On him depends the continuity of its tradition, the maintenance of discipline, and the efficiency of its teaching. Thus, any act which a headmaster is taking for the benefit of the children and for the for their development. Cases are there, and wherein it was said that while discussing parental and quasi-parental authority, it is stated that a schoolmaster has the power of chastisement over a pupil committed to his charge, arising from delegation by the parents or guardian, but the same should be reasonable and should not be excessive in nature, is what has been stated by the court in various cases. Even in Mrs. Balaji versus the principal, which is also one of the latest case, and it's an important case where the court has talked about the parental and quasi-parental authority, and it has been stated that when we talk about parental quasi-parental authority, the most important, it is this most important aspect in the welfare of the child, and it has been stated that wherever the question for upbringing of the child is concerned, welfare of the child is concerned, here parents and people who are placed in the position of parents are under duty bound and have this right over the child to take certain steps within the defined limits, and that should not be excessive for the betterment of a child. As from the current discussion, we can say this, that the authorities having a quasi parental authority have the duty to take every care with regard to the students as that of parents themselves, but no school, no teacher will exceed the act to what is required. It should not be excessive in nature. Moreover, they cannot harm the children with regard to their personal problems unless the concern is with respect to their academic progress. It has been also stated by the court that not even parents have the right to spoil the future of a child, because the main consideration is to take care of the future of the child and the welfare of a minor child. So these are certain points that are laid down by the court for parental and quasi-parental authority. Hope the topic is clear to you. Have a nice day. Take care.